Well, Hunter Biden and his tax scandal keeps heating up. Today, the House Ways and Means Committee have dropped major bombshells in testimonies from two IRS whistleblowers who detailed various allegations in a closed meeting. A team of IRS agents had been looking into whether Hunter Biden committed tax violations, which was a part of the federal probe operated out of Delaware by attorney David Weiss since 2018. As we know, a few days ago, after a long and drawn-out, nearly 5-year investigation, the president's son reached a plea deal with the Department of Justice. Papers filed in a federal court in Delaware indicate that Hunter Biden will plead guilty to 2 misdemeanor tax charges of failure to pay in 2017 and 2018. 2 whistleblowers who had been investigating the president's son had already made several allegations about the way in which the DOJ and high-ranking IRS officials had handled the probe, believing it had examples of preferential treatment, conflicts of interest, and was slow-walked. Chairman of the House Ways and Means Committee, Jason Smith, has laid out 3 key findings that IRS whistleblowers have detailed.
There are 3 areas of focus in the transcripts of interviews with whistleblowers. Number 1, the federal government is not treating taxpayers equally when enforcing tax laws. Number 2, whistleblowers claim the Biden Department of Justice is intervening and overstepping when it comes to the investigation of the president's son. And number 3, these whistleblowers report they have faced almost immediate retaliation.
Chairman Smith said these tax crimes the IRS had said Hunter Biden had committed covered an estimated $2.2 million in unreported tax on global income streams to Hunter Biden and his associates from Ukraine, Romania and China. This totaled to $17.3 million from 2014 to 2019, $8.3 million of which Hunter Biden personally pocketed. Republican Jason Smith said that these transcripts should show a world of wealth and influence that no ordinary American would recognise. He continues slamming the president's son's slap-on-the-wrist plea deal made with the Department of Justice, believing the federal government is not treating taxpayers the same. Mr. Smith claims that all of this meant that officials actually wanted a more serious outcome for Hunter Biden than what he received a few days ago.
IRS recommended charges against Hunter Biden that included attempt to evade or defeat tax, a felony, fraud or false statements, a felony, and willful failure to file returns, supply information, or pay tax.
One of the whistleblowers, Gary Shapley, was unmasked when he sat for an interview with CBS last month, where he spoke about his time working as a supervisor on the investigation into Hunter Biden's taxes.
There was multiple steps that were slow-walked at the direction of the Department of Justice.
Had you ever encountered that before?
I have not, no. These deviations from normal process, and each and every time it seemed to always benefit the subject.
Gary Shapley was the first whistleblower who had been the supervisor on the probe since 2020. The second whistleblower was an agent who had been working on it since the probe began in 2018. Both testimonies are full of interesting allegations, but today I will go through just Gary Shapley's testimony to Congress, which is now public. Within his testimony, he not only states that he was passed off for a promotion last year as retaliation, but also goes into further detail about the DOJ's involvement. He says the case agent on this case is one of the best agents in the entire agency. Without his knowledge and persistence, DOJ would have prevented the investigative team from collecting enough evidence to make an informed assessment, which ultimately included even DOJ agreeing on the recommended criminal charges. I am alleging, with evidence, the DOJ provided preferential treatment, slow-walked the investigation, did nothing to avoid obvious conflicts of interest in this investigation. He continues, but whatever the motivations, at every stage decisions were made that had the effect of benefiting the subject of the investigation. These decisions included slow-walking investigative steps, not allowing enforcement actions to be executed, limiting investigators' line of questioning for witnesses, misleading investigators on charging authority, delaying any and all actions months before elections to ensure the investigation did not go overt well before policy memorandum mandated the pause. In April, Gary Shapley's attorneys came forward seeking whistleblower protection for their client from Congress so that he could share how the investigation had been improperly handled. He claims he was then retaliated against because he and his entire team were then taken off the investigation and replaced. Mr. Shapley goes on to detail that Hunter Biden's code name was Sportsman and that FBI agents had given them the heads up that the now president's son's laptop was in their possession, which possibly contained evidence of tax crimes. After working closely with the FBI, DOJ, and Delaware Attorney's Office for a while, Mr. Shapley said it soon became clear to me this case was being handled differently than any I'd seen before. In 2020, Gary Shapley was seeking approval to conduct various fiscal search warrants and contemporaneous interviews, but claims, yet after former Vice President Joseph Biden became the presumptive Democratic nominee for president in early April 2020, career DOJ officials dragged their feet on the IRS taking these investigative steps. Another example of this probe being slow-walked was when Mr. Shapley and his team got the results back from Hunter's iCloud and wanted to follow up on it. Nevertheless, prosecutors denied investigators' request to develop a strategy to look into the messages and denied investigators' suggestion to obtain location information to see where the texts were sent from. Within these text messages from 2017, it detailed a working relationship between Hunter Biden and Chinese businessman Henry Zhao, who was a Communist Party official, and tries to strong-arm him by saying, "I'm sitting here with my father." He then threatens him, saying, "I will make certain that between the man sitting next to me and every person he knows and my ability to forever hold a grudge, that you will regret not following my direction. I'm sitting here waiting for the call with my father." Keep in mind, this is all happening even as Joe Biden has continued to maintain that he has never spoken to his son about his overseas business deals. Within his testimony, Gary Shapley even says Assistant United States Attorney Leslie Wolf hadn't seen all the evidence, which included content from Hunter's laptop. Leslie Wolf stated that she would not have seen it because, for a variety of reasons, prosecutors decided to keep it from the investigators. This decision is unprecedented in my experience. Investigators assigned to this investigation were obstructed from seeing all the available evidence. It is unknown if all the evidence in the laptop was reviewed by agents or by prosecutors, based on guidance provided by the prosecutors on a recurring basis to not look into anything related to President Biden. There is no way of knowing if evidence of other criminal activity existed concerning Hunter Biden or President Biden. One of the biggest bombshells to come out of this testimony from Mr. Shapley is about whether Biden-appointed Attorney General Merrick Garland lied under oath when he said that he wouldn't interfere with the investigation.
Steps has the Justice Department taken to determine the truth and accuracy of information provided? Congress and the American people, I think, have a right to know.
I have pledged not to interfere with that investigation, and I have carried through on my pledge.
Within that testimony, Mr. Garland swore that David Weiss had full authority to bring cases in other jurisdictions if he felt necessary, claiming he wouldn't be denied anything. Mr. Shapley said that last year, from March to October, he was under the impression they were still deciding whether to charge Hunter with tax violations from 2014 and 2015. However, I would later be told by United States Attorney Weiss that the DC US Attorney would not allow US Attorney Weiss to charge those years in his district. This resulted in United States Attorney Weiss requesting special counsel authority from Maine DOJ to charge in the District of Columbia. I don't know if he asked before or after the Attorney General's April 26, 2022 statement, but Weiss said his request for that authority was denied and that he was told to follow DOJ's process. This is something that Mr. Garland was actually asked about under oath. Senator Chuck Grassley asked Merrick Garland, because the David Weiss is not a special counsel, then would he have to seek permission from another US attorney to bring charges outside of Delaware? To which Merrick Garland said that he would leave the matter of Hunter Biden up to David Weiss, saying he won't interfere at all. But according to Gary Shapley, that request was denied. That process meant no charges would ever be brought in the District of Columbia, where the statute of limitations on the 2014 and 15 charges would eventually expire. The years in question included foreign income from Burisma and a scheme to evade his income taxes through a partnership with a convicted felon. There were also potential FARA issues related to 2014 and 2015. The purposeful exclusion of the 2014 and 2015 years sanitised the most substantive criminal conduct and concealed material facts. While there's so much more involved in Gary Shapley's testimony, he concludes by stating that on May 15th, after his attorney wrote to Congress seeking whistleblower protection, he was informed that the DOJ had requested his entire team be stood down in the investigation. He finishes, "I did not choose to sit here before you today. I was compelled by my conscience when decision after decision had been made to deviate from our normal investigative processes. I believe Congress needs to know this information."